The Constituent Assembly after this functioned as a legislature of Jammu and Kashmir also. And they made other laws also. I have given the list.
It was primarily to ensure enforcement of 370 articles of clause 1, which power was vested with the legislative assembly. So they vested it with the
Constituent Assembly, so that laws can be made by the Constituent Assembly. Otherwise, Constituent Assembly is not a law-making body in that sense. Of course, my submission is that Constitution of Jammu and Kashmir is at par with the legislation only. It's not a kind of a constitution as we understand, as a document of governance. To page 59. Look, these are the laws made. I'm not reading, it's not necessary. I'm sorry, my Law Justice call is conferring. Look, these are the laws which were made by the Constituent Assembly, acting as a legislative assembly of Jammu and Kashmir. Page 59. Page 59, up to page 60. But your lordships can consider noting here that exercise of mechanism under Article 367 to make changes in 370 is undertaken 4 times, which I'll come periodically. And whenever some body was not available, the successor body was named. Okay, I'm sorry.
Yes.
I'm sorry. I thought my lord the Chief Justice is writing.
Yes.
This exercise or use of mechanism under 367 was directly in issue in Damnu judgment. Yeah. And it is approved by your lordships, speaking through the Constitution bench. But then comes Puranlal Lakhanpal. I'm not reading it because I don't think anything turns on that either for me or for the other side. It would not render any assistance. It just records the history. That's all, which we have already given. Now, your lordships, kindly see page 62. The State Reorganization Act comes. It does 2 things. One, Part A and Part B states are clubbed into one called states. So Jammu and Kashmir ceased to be Part B, but it became a state like any other state. And Part C states became union territories. That is first. Sorry, C and D both became Andaman Nicobar was D. So A and B became states and C and D became union territories. We are not concerned with that right now in this matter. Second was the identity of princely states was completely abolished. Till then, till 56, the Raj Pramukh was the erstwhile princely ruler. This was abolished. That now, henceforth, it would be the governor appointed by the President of India. The President who is responsible to the Parliament and the Parliament who is responsible to we the people of India. So now, no Raj Pramukh, who is the princely state. He can be appointed as a governor. That's one thing. Some of them were appointed, but not by virtue of they being a member of that lineage in the princely states. But this happened. But at this stage, Article 238 was repealed, rather omitted, not repealed, but it was omitted by 7th Constitutional Amendment. But your lordship separate.
So another thing.
But please come to page 63 only for one date which is relevant. I'm not reading anything.
Page?
Page 67, 63, 17/11/56, the constitution of the state of Jammu and Kashmir is framed. The document called Constitution of Jammu and Kashmir is framed. That's all. Thereafter, straightway, my lord, I have, my lord, given excerpts from the debates which essentially says that Jammu and Kashmir is an integral part of India. I don't think that is something which is not required to be labored much. Therefore, I am not skipping.
Nobody does that also.
Yes, no, therefore, I am skipping that. Please come directly to page 67, my lords. The second use of the mechanism under Article 367. Your lordships would recall, in the first use, the Honorable President said Constituent Assembly and Legislative Assembly are used interchangeably. But at this stage, the Constituent Assembly ceased to exist because the Constitution was framed. Therefore, please come to, my lord, page 67.
This is CO 56, right?
Yes, my lord. CO 56 dated 26th February 58. It was required in 58 because of a constitution of Jammu and Kashmir being framed and Constituent Assembly ceasing to exist, and because of the State Reorganization Act. Please see, my lord, at page 67 bottom, T is deleted. He read reference to the legislature or the legislative assembly of the said state shall be construed as including reference to the constituent assembly of the said state. Because the constitution was framed, constituent assembly ceased to exist, and therefore, my lord, this clause was amended. And E, the term Raj Pramukh was replaced by the word governor because of the State Reorganization Act. Now, Raj Pramukh system has gone.
Yes.
Phraseology used was governor henceforth from this.
Yes, henceforth it was governor.
But the phraseology used to head of the elected government as prime minister did not cease with this.
I beg your lordship's pardon.
Chief minister used to be called the prime minister there.
Yeah, that went, my lord, after Sadr-e Riyasat itself. It became Sadr-e Riyasat. Prime Minister went.
Went after that. Only as a matter of sequence of dates I want.
Yes, yes. It became Sadr-e Riyasat, and thereafter, my lord, Raj Pramukh, and thereafter governor. Now it remains governor throughout thereafter. Now kindly see, my lord, page 69. I'm skipping the rest, my lord. They are, my lord, Lord, kindly see, my lord, first page 68, Premnath call, but the first judgment,
Yes.
it was more on the competence of the Yuvraj. And therefore, my lord, I believe it may not render
Can we
assistance.
just read that para?
Yes, I'll, my lord, please. The Supreme Court renders its judgment in Premnath Kaul versus State of Jammu and Kashmir. It's a 5-judge bench, my lord. The issue before the court was the validity of Jammu and Kashmir Big Landed Estate Abolition Act, which was enacted by the Yuvraj in exercise of powers vested in him under Section 5 of Jammu and Kashmir Constitution Act, 1996. Well, 1996 is Samvat year, 1939, the old constitution. The judgment discusses the constitutional history of the state in great detail and at the same time discusses the power of Maharaja under the previous constitution of the princely state. The question before the court was whether the provision of Article 370, sub-Article 1 till the time the Constituent Assembly of Jammu and Kashmir was in session, affect the plenary powers of Maharaja in the matter of governance of the state. In this context, the court held that the act in question, which was enacted in 1950, would not stand interdicted by Article 370 and held that Yuvraj was competent to enact the act. The case effectively concerned the issue of legislative competence of Yuvraj when there is no Constituent Assembly of Jammu and Kashmir. Yes. But in this very proceedings, when there was a request for a reference to a larger bench, in this very petition, Lord, the 5-judge bench, Lord, speaking through my Lord Justice Call, exactly said this, that it may not have bearing on the either side. Now, my Lord, page 69. Now, my Lord, the integration of judiciary. Slowly, my Lord, some provisions came to be applied, truncated, some full, some modified, some with exceptions. But Article 222 was made applicable regarding transfer of judges. Earlier, my Lord, till 60, the honorable judges of the High Court were not transferable by the Supreme Court. But the oath was prescribed, and till 2019, the honorable judges of Jammu and Kashmir High Court used to subscribe to this oath. Please see. Oath or affirmation to be made by judges of the High Court. I, Sri So-and-so, having been appointed Chief Justice or a judge of the High Court of Jammu and Kashmir, do swear in the name of God, solemnly affirm that I will bear true faith and allegiance to the Constitution of the state. So, they were, my Lord, under an obligation because of Article 1, and they were applying the Constitution of India. But the oath which they used to take was expressing their allegiance to the Constitution of Jammu and Kashmir state. Even the Honorable Chief Justices, my Lord, who would be appointed there, would be taking this oath. That's it, my Lord, nothing beyond. Now, your Lordships may kindly come to Puranlal Lakhanpal judgment, my Lord, where I would read only one para, my Lord, of that judgment, because something turns on that, and I will show, my Lord, Sampath Prakash thereafter, my Lord. At this stage only, my Lord. Please come to, my Lord, Case Law Compilation, Volume 1. Page 24, my Lord. Only para. Kindly see, my Lord, in those days, my Lord, what used to.
Which one did you say?
I'm sorry,
Volume 1.
Case Law Compilation, Volume 1, PDF page 24. Well, somebody wanted to stand for election to be elected to the House of People, that is Lok Sabha. He filed this petition. Please see, my Lord, page 1 and 4. My Lord, only 2 would be relevant, my Lord. Am I with your Lordships on page 5? My Lord, 24? Premnath Kaul, my Lord. The petition challenges the constitutionality of a provision in the Constitution Order 54 made by the President under Article 371. The case of the petitioner is that he is registered as an elector in the parliamentary constituency of Delhi. As such, he has a right to stand for election from any parliamentary constituency in India. 6 seats are allotted to the state of Jammu and Kashmir in the House of People, Lok Sabha. Ordinarily, the election to these seats should have been direct election from the territorial constituencies in the states as provided by Article 81(1). And this is what was happening in rest of the country. But the President modified that article insofar as it relates to the state of Jammu and Kashmir by para 5C of the order in these words. Article 81 shall apply subject to the modification that the representatives of the state in the House of People shall be appointed by the president on the recommendation of legislature of the state. No direct election in Lok Sabha. It's like Rajya Sabha. And the contention was, the petitioner contends that the president had exceeded his powers when he made this modification, for he thereby substituted direct election to the House of People by nomination which he could not do. This, it is said, was a radical alteration. But please mark these words.
Yes.
Yes. Now kindly, my lord, come to para 4. The court says even radical modification is permissible. But even assuming that the introduction of indirect election by this, my lord, your lordships have para 4, my lord, at page 25. May I read with your lordship's permission? But even assuming that the introduction of indirect election by this modification is a radical alteration of provisions of Article 81(1), the question still remains whether such a modification is justified by the word modification as used in Article 371. We are hereby dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. The question that came for consideration in Delhi Law's case was with respect to power of delegation to a subordinate authority in making subordinate legislation. It was in that context that the observations were made that the intention of the law there under consideration when it used the word modification was that central government would extend certain laws to Part C states without any radical alteration in them. But now this is the ratio. But in the present case, we have to find out the meaning of the word modification used in Article 370 subarticle 1 in the context of the Constitution. As we have said already, the object behind enacting Article 370 subarticle 1 was to recognize the special status of state of Jammu and Kashmir and to provide for that special provision by giving power to the president to apply the provision of the Constitution to that state with such exceptions and modifications as the president might by order specify. We have already pointed out that the power to make exceptions implies that the president can provide that a particular provision of the Constitution would not apply to that state. If therefore the power is given to the president to efface in effect any provision of the Constitution altogether in its application to the state of Jammu and Kashmir, it seems that when he is also given the power to make modifications, please note, my lord, mark, that power should be considered in its widest possible amplitude. If he could efface a particular provision of the Constitution altogether in its application to the state of Jammu and Kashmir, we see no reason to think that Constitution did not intend that he should have the power to amend a particular provision in its application to the state of Jammu and Kashmir. It seems to us that when Constitution used the word modification in Article 371, the intention was that the president would have the power to amend the provisions of the Constitution if he so thought fit in their application to the state of Jammu and Kashmir. But thereafter, dictionary meanings, etc., is quoted. Lord, why I am reading this? Lord, Mr. Nafde urged that this is an obiter and therefore not laying down any law. Lord, in Sampat Prakash, subsequent judgment, again, my lord, the same Lord, numerical strength, 5 honorable judges, reproduces this para, relies upon it as a ratio. It's not an obiter. Lord, let me directly go to Sampat Prakash so that this point is clear. This is not an obiter. This question directly fell for consideration. The petitioner wanted this honorable court to interpret whether there is any power of radical alteration or modification. And this honorable court said, you can even efface a part of the constitution. Then obviously radical alteration is something which you can do. Now, Lord, in the same compilation, if your lordships can come, the next judgment, my lord.
27.
Yes, my lord. Please come to, my lord, page 27. This was a detention case. Please come to para 2. At page 28. Does your lordship not have them? I'll just read para 2. During the preliminary hearing of this petition, Mr. Ramamurthy, representing the petitioner, it was, my lord, a detention case, raised a ground that section 13A of the act, under which, my lord, the local act, under which the petitioner was detained, was ultra vires the constitution as contravening the provisions of article 22 of the constitution. That question was referred by the constitution bench to the court to a larger bench and came before the full court. On this occasion, the court held that in view of clause C of article 35 of the constitution introduced in the constitution in its application to the state of Jammu and Kashmir, the point that had been raised stood answered by the addition of this clause, and unless the clause itself was challenged, the point raised on behalf of the detainee did not arise. In this view, the reference was dissolved and the case has been heard by the constitution bench. They said that till you challenge 35C, obviously fundamental rights under 21, 22 are not applicable to a detainee. My lord, thereafter, my lord, your lordships may kindly come to page 29. Look, this takes care of Mr. Dwivedi's argument. Mr. Dwivedi for the petitioner. No, but on this side also we have Dwivedi.
You have to argue anything.
Yes.
That's in a brotherly sense.
Yes, sir. 29. The first argument, my lord, your lordships would find after, my lord, quotation of the section. The first argument was that this article contained temporary provisions which ceased to be effective after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir state had completed its task by framing the Constitution for that state. Reliance was placed on the historical background in which this Article 370 was included in the Constitution to urge that the powers under this article were intended to be conferred only for the limited purpose and limited period until the Constitution of the state was framed, and the President could not resort to them after the Constituent Assembly had completed its work by framing the Constitution of the state. The background or the legislative history to which reference was made was brought to our notice, my lord, that your lordships can, my lord, skip. Then your lordships may kindly see para 5, my lord. Lord, your lordships can, my lord, directly come to 7, my lord. There are, my lord, your lordship gets, my lord, at page 30, at the foot, para 7. There are, may I read? There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state has passed the Constitution of the state. The most important provision in this connection is that contained in clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. This clause clearly envisages that the article will continue to be operative and can cease to be operative only if, on the recommendation of the Constituent Assembly of the state, the President makes a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by the President declaring that article shall cease to be operative. Both things are separately mentioned. Neither recommendation made nor President exercised, meaning thereby the President could have exercised the powers even in absence of a recommendation, since there is no Constituent Assembly. I hope, Lord, I am able to make myself clear that till Constituent Assembly was in existence, recommendation. Even otherwise, President could have done it after the Constituent Assembly ceased to exist. On the contrary, it appears that the Constituent Assembly of the state made a recommendation that the article should be operative, with one modification to be incorporated in the explanation to clause 1 of the article. This modification in so and so. My lord, thereafter, kindly come to the real issue, my lord, that is 14. There are 13, my lord.
13 or 14?
13, my lord, first. The next point urged was that Article 368 of the Constitution having been applied to Jammu and Kashmir with a proviso added to it, there now exists a provision relating to amendment of the Constitution as applied to Jammu and Kashmir under this article, and consequently, while such special provision for this purpose exists, we should interpret Article 370 as being no longer applicable for amending or modifying the provisions of the Constitution applied to that state. This is what was argued by Mr. Nafde. Now, please see what your lordship say. Para 14. I'm sorry, I'll read it for you. This argument, in our opinion, is based on a wrong premise. Article 368 has been applied to Jammu and Kashmir primarily with the object that amendments made by Parliament in the Constitution of India, as applicable in the whole of the country, should also take effect in the state of Jammu and Kashmir. The proviso, when applying this article, serves the purpose that those amendments made should be made applicable to the state of Jammu and Kashmir only with the concurrence of the state government, and after such concurrence is available, these amendments should take effect when an order is made under Article 370 of the Constitution. Thus, Article 368 is not primarily intended for amending the Constitution as applicable to Jammu and Kashmir, but is for the purpose of carrying the amendments made in the Constitution for the rest of India into the Constitution as applied in the state of Jammu and Kashmir. Even in this process, the powers of the President under Article 370 have to be exercised, and consequently, it cannot be held that applicability of this article, that is 368, would necessarily curtail the power of the President under Article 370. It was also urged that the power of making modifications and exceptions in the orders made under Article 371D should at least be limited to making minor alterations and should not cover the power to practically abrogate an article of the Constitution applied in that state. The submission is clearly without force. The challenge to the validity of Article 35C introduced in the Constitution as applied to the Jammu and Kashmir on this ground was repelled by this court in PN Lakhanpal versus State of Jammu and Kashmir. Subsequently, the scope of the powers of making exceptions and modifications was examined in greater detail by this court in Puranlal Lakhanpal.
Yes.
And that is, my lord, which I read, para 4, which as per Mr. Nafde was a near obiter, but the subsequent bench treats it as a ratio, relies upon it, and holds the same thing. But please come to, my lord, now just before one line before paragraph 15. I'm sorry. para, page 34, just above para 15. This decision, Your Lordship gets, Madam. How the subsequent 5-judge bench treats Puranlal Lakhanpal, para 4 of Puranlal Lakhanpal, which, my lord, Mr. Nafde contended is a obiter. This decision being binding on us, it is not possible to accept the submission urged by the council. So Puranlal Lakhanpal, para 4 is treated as a ratio. Then 15.
Yes.
May not be of relevance, my lord. I'll just come back to my written submissions, my lord, again. That's on the facts. The rest is, my lord, on the facts of the case. Lord, please come to page 70. Here, parliamentary supremacy,
70 of your submissions.
my submissions, my lord. That would be combined submission, volume 3. (246), my lord, was applied with some modification, of course. Please. Lord, CO 66, Article 246, which was originally applied in 1954 with only one clause, was applied with modification that Parliament would have the power to make laws in the Union list and some entries in the concurrent list applicable to Jammu and Kashmir. Article 254 was applied in toto, thereby ensuring supremacy of the parliamentary laws in case of repugnancy. Lord, rest, there are some additions, my lord, which may not be of much assistance, my lord. Kindly come to page 71. Once again, the Lok Sabha, my lord, takes up this issue. And where, my lord, those famous words of the Honorable Prime Minister Nehruji, my lord, are reproduced. Only underlined portion. As a matter of fact, as the Home Minister has pointed out, it has been eroded, if I may use the word, and many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. I repeat that it is fully integrated. The provision eroded. Most of the provisions are applied according to the situation of the day, and it was awaiting of being extinguished right from 64 onwards. Then, my lord, para page 72, CO 69, my lord, this provisions of Article 19, subclause 7 was added, and 35C were extended from 10 years to 15 years. My lord, as I have pointed out, my lord, it came to be kept on being extended till 74. Now, my lord, a private member's bill comes before the Parliament for abrogation of Article 370. Please see, my lord, the debate, the underlined portion only, my lord, for brevity, my lord, so that I don't, my lord, waste more time of your lordships. Inder Malhotra, nominated from Jammu and Kashmir, says this: the people of the state have no special liking for this Article 370, which exists in the Constitution, and we shall be very happy as soon as this is omitted. This was the debate, whether it should be omitted, it should be abrogated, etc. Then Hari Vishnu Kamath. He was also a member of the Constituent Assembly of India. A very leading member, one of the members who contributed immensely. That accession is irrevocable and that integration must come very speedily. If that is accepted, then there cannot be two opinions on the question. That article must go. I take my stand so far as this article is concerned on the firm base that now Jammu and Kashmir state is suffering because this article is there, because difficulties are there by created. If this article is repealed, the state will derive some benefits as other states of the union are deriving from their relationship with the Indian Union. And therefore, it is from that point of view, that Jammu and Kashmir should be as much a beneficiary of the relationship with the Indian Union as every other state, such as Mysore or Kerala or Bengal or Maharashtra or Madhya Pradesh is today. And unfortunately today, Jammu and Kashmir is not a beneficiary of this relationship in the same way and to the same extent as other states. Then my Lord Shamlal Saraf, my Lord, adds, retaining Article 370 by not bringing the state at par with the states in the rest of the country. What has been happening? Firstly, there is a sort of insecurity in the minds of the people. Secondly, I will say this frankly, in certain cases, local vested interest, some of them may have been my colleagues, want to have the best of everything and want to take advantage of the present situation. Without bringing any communal, sectarian or any other view into the matter, I will say that purely from the people's point of view, the people of state have suffered. Once these barriers are removed, once they are allowed to function as any other part of the country, the people will very much benefit. But what was barrier for the people was being canvassed and people were being convinced as a privilege to fight for. Then, my Lord, Sri Sonavane in the chair. My Lord was from Jammu and Kashmir, my Lord, in the parliament. Then, my Lord, Sri Sonavane in the chair, underlined portion. There is the non-application of labor laws. In my state, there are lakhs of people working in various forests, handicrafts and factories, and all the beneficial laws that we have in the center and which are applicable to the rest of the states, as Nandaji knows, as ex-labor minister, that is Gulzarilal Nanda, my Lord, became acting prime minister twice, labor minister, should ipso facto apply to that state also. I have myself been a small labor worker, and as a minister, I was in charge of labor also, and I know the feeling of workers in that state. Every time they say, why do you keep this wall of separation? Let us all get tile benefit as the rest of our countrymen. After all, in labor, where people work, there is no question of caste, color, or religion. Therefore, it is equally important, and I would say forcefully, that these things should apply there also. Then, my Lord D.C. Sharma, my honorable friend Sri Gopal Dutt Mengi has said that Article 370 is a wall. I would say it is not a wall. If it was a wall, I could demolish the wall easily and in no time. It is not a wall, but it is a big mountain which stands between India and Jammu Kashmir. Although we have dug the Bani Hal tunnel and we have done everything else, we have not demolished the mountain yet. I feel this mountain should be blasted with dynamite, with the dynamite of goodwill, firmness and decision. That way lies the salvation of India, and that way lies the good and welfare of the people of Kashmir. Then, my Lord, at the foot of this page, my Lord, in the debate, Sri Abdul Ghani Goni, the people of Kashmir had decided once and for all, and have decided once and for all, that Kashmir is an integral part of India. Whether there is Article 370 or no Article 370, it is only a provisional provision and a temporary provision in the Constitution which can be removed at any time. But as far as the complete accession is concerned, that is final and nobody can challenge it. Then, my Lord, Mansingh Patel on the next page, 76. I am skipping the rest. Lord, Mr. Ghoni, my lord, I'm told, was also a member of Constituent Assembly of Jammu and Kashmir. And thereafter, he was a minister also. Then, my lord, Man Singh Patel, we have said before the world as a whole that there is no possibility now of plebiscite and the integration of Kashmir is firm, final and irrevocable. We continue with this Article 370, thereby showing to the world as if there is still some difference between Jammu and Kashmir and other states of the Indian Union. This kind of maintenance of separate identity of a state creates difficulty for us. Chatterjee, my lord, I'm not reading, voices the same sentiment. Please come to, my lord, page 77, Sri S.S. More, only highlighted part.
But,
I'm sorry, my lord, my learned friend wants me to.
Minister, very interestingly, Mr. Chatterjee refers to the statement of Mr. Sadiq, who was the.
Yes, my lord, I'm sorry, my lord, I would, my lord, rather read that.
Vice President.
I have,
of National Conference. Vice President of National Conference.
yes, my lord. I have in my extra hand an extract from Hindustan Times dated so-and-so, which reads thus: the veteran founder title and National Conference leader, Mr. Sadiq, today confirmed reports of lawlessness and corruption in the administration of Jammu and Kashmir. Mr. Sadiq, I'm told, was the Honorable Chief Minister then.
He took over after Bakshi government.
Yes, madam. Mr. Sadiq, who is the senior vice president of the ruling National Conference, declared in an interview that abrogation of Article 370 of the Constitution was essential for the restoration of normalcy in that state. I maintain that it is today more imperative for the restoration of normal conditions, for the upkeep of democratic life of that state, and for greater cohesion, both of the people of Kashmir and India as a whole. We should not delay any further. What has happened since 29th of November 63 till today, which necessitates that there should be any going back on the solemn declaration that Article 370 must be abrogated and it is essential for restoration of normal conditions in that state. What is heading of this chapter, that chapter? It is in part 21 of the Constitution, temporary and transitional. Therefore, Article 370 was never 77, the last four lines of NC Chatterjee, Manoj.
Yes.
Therefore, in the very content of this article, there is a clear demarcation, a clear expression of the will of the makers of the Constitution that it shall not be permanent feature, and the President, by a declaration, by a notification, can say that this article shall cease to operate. Lord, why I am reading this, the argument of the petitioner was that once the Constituent Assembly of Jammu and Kashmir is dissolved without recommending anything, it became permanent. I am just pointing out that subsequently also two things are happening. Everyone says it is temporary and everyone expresses the desire. Why is it not being now?
These are views really. These
Correct.
are views on the floor of the.
But, my lord, please see Mr. More's view. He has articulated, my lord, beautifully on that very page. Next, I rise to accord my hearty support to the present bill. I have read article, I'm sorry, they are views. This is how Parliament understood it.
Not
That's-
Parliament, an individual member of Parliament.
My lord, this is how, my lord, nobody disputes that no, it is permanent.
It was not the view of the government of India, at least, because they would have done it then.
No, our my lord, law minister has said, the honorable prime minister has said.
These are individual views which.
What happened to the bill, but?
Private member bill,
It was a private.
the private member bill, it's not carried.
What he is reading, Mr. Subban, is the sentiment running across.
But Manas, when you read the whole debate, Manas, he's only given you parts. The whole debate is.
There will be,
Time.
there will be debates in favor, there will be debates against.
That's what I'm so.
Ultimately, Mr. Solicitor, we have to construe the Constitution. We can't really, these are not really expressions of view by Parliament as a collective body.
This is
Right,
how,
because
my lord, it
members
was
say
understood.
something.
That's all. I leave it at that. Now, my lord, kindly see the view of the government at page 78 bottom. 4th December 1964. In continuation of the debates mentioned above in a speech, then Home Minister Gulzari Lal Nanda reaffirmed the temporary nature of Article 370. This is the view of the government. There is no wall between Jammu and Kashmir and India. At the most, you can say it is some kind of a movable partition. We can move it on our own. There is nothing coming in the way. This is the view of the government also. I take this opportunity to inform the House that it has been decided to apply the provisions of Article 356 and 357 also to Jammu and Kashmir. Entry 43 and 78 of the Union list and 33 and 34 of the concurrent list are also being made applicable. I skip a lot, then the highlighted part. Therefore, the area of uniformity is being constantly extended and it is being accelerated and expedited. And as I said before, the House would certainly understand from what I have said that anything else which has to be done quickly could certainly be considered and some kind of action could be taken on that. The government assures the Parliament. Then Hembara, when you have done so much, why don't you do the rest? Sri Nanda, those who have done so much will certainly do the rest.
The concurrent list was made applicable with, of course, modifications by CO 66, right? Just for the sake of.
Yeah,
CO
yes.
66?
For the first time, yes, my lord.
That is 26th of September 1963, right?
My lord, sir. Now comes, my lord, third instance of mechanism under Article 367, page 80, my lord.
The substitution, that is what I was asking for a fact only, Mr. Solicitor.
Yes, my lord.
Only in 1965 that the expression Prime Minister changes to Chief Minister. Your list of dates of 10/4/1965.
No, my lord, Prime Minister description went long back.
Please-
Sadr-e Riyasat was changed.
Please read 10/4/1965.
No, your lordships are at page.
Your notes.
Your note.
Oh, okay, well, your lordships are right. Though this act, the expression Sadr-e Riyasat and Prime Minister in the state's constitution were to respectively be, your lordships are right. It was
I had an impression, I was not sure, that both things occurred
In the constitution of Jammu and Kashmir.
Kashmir occurred simultaneously.
Yeah, your lordships are right. Now I stand corrected. I was, my lord, answering the constitution of India point of view when it changed, my lord, in 367. But your lordships are right, in their, in the constitution of Jammu and Kashmir, my lord, it was simultaneous in 65. And my lord, CO 74, so that is page 80. Lord, please see at the foot what changes were made. Lord, CO 367 was the mechanism of Article Article 367 of the Constitution was amended so as to give effect to Article 370. Please see, my lord, AA, this is addition in green. The lordship gets, my lord. References to the person for the time being recognized by the president on the recommendation of the Legislative Assembly of the state as Sadr-e-Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office shall be construed as references to the governor of Jammu and Kashmir. References to the government of the said state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of his Council of Ministers, provided that in respect of any period prior to 10th day of April 55, such references shall be construed as including references to Sadr-e-Riyasat. Then E was already deleted. E was already deleted. I have just kept it here, my lord, as a record for continuous. It was not deleted by this CO. It was earlier deleted, which I have already shown to your lordships. Lord, this change was the subject matter of Muhammad Maqbul Damnu, this particular CO. Lord, I'll have to read some paragraphs of Damnu, my lord. Can I do it after the lunch break, my lord? It's now a few minutes.
Just as an aside, Malad, during these debates, Malad, Pandit Jawaharlal Nehru intervened and he said, if you talk about outsiders buying land in Jammu Kashmir, I am totally opposed to it because big business will come in, Malad, and will destroy the entire state completely. So he was very adamant on that.
That was a mistake, my lord. My
I'm sure
understanding
it
is
was a
right,
mistake.
my lord.
I'm only saying those
That
parts,
was,
those
my
parts should
understanding
also
is
be
right.
read. Those parts, I'm not saying.
That, my lord.
Everything that we did was always a mistake. Malad.
No, I'm not being political, my lord. I'm from citizens' point of view. Unless investment comes, you never develop.
Why it did not culminate into something?
Just for the record for that debate, 23 for, 157 against, 160 pages of debate. Guzari Nanda says that you cannot change 370 till you follow 370. So all that, well, what is happening is we're expanding all this, which is not part of any.
I may assure my learned friend.
Well, at least you should point the facts out.
Lord, there is no intention, Manoj. Everyone, we were led by eminent people, everyone contributed. There is no, Lord, undermining the contribution of anyone. The only purpose was voting may differ. This was the view consistently explained, and Lord, my only purpose of reading was, this is how the country treated it as temporary. That's all. My learned friend may take any other meaning out of it. Everyone contributed, but even 370 must have come with good intention of integrating the nation. The purpose of reading the debate was, and is, my lord, I'm not reading it now, that it was conceived from the beginning as a temporary provision. That's all, my lord. That not to undermine anyone's contribution. Lord, I pointed out CO, and now, my lord, I requested your lordships to allow me to place only 4 paragraphs of Damnu. Your lordship knows, my lord. Case law compilation, my lord, volume 1, 36 at 44. I'll read only the relevant part. Volume 1 compilation, page 36 at 44. But before rising for lunch, when your lordships rose for lunch, I read the constitution order, which was under challenge. Makbul Damnu. Para 19, Manoj. At page 44, your lordships would find Article 367 as modified is quoted. Then para 18 may not be relevant, 19. Your lordship gets that. May I read with the lord's permission? On November 17, 1956, Jammu and Kashmir Constitution was adopted. Some sections came into force on that date, and remaining sections came into force on January 26, 1957. But nothing turns on that. At the last 2 lines of that para, my lord, order of 1965, under this order, for clause B of clause 4 of Article 367, the following clauses were inserted. Lord, then Sadr-e Riyasat becomes governor of Jammu and Kashmir. Correct, Manoj? Now please come to 21. According to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at that time. It says at that time because 65 was the CO, 65 or 66, but the matter was heard, my lord, somewhere in 70s. Therefore, nothing turns on that. According to Mr. Garg, this is the kingpin of the whole relationship between the Union of India and the state of Jammu and Kashmir. According to him, neither the Jammu and Kashmir Assembly nor the President were competent to impair the functioning of Sadr-e Riyasat, and insofar as Constitution of Jammu and Kashmir Order of 1965 replaced the Sadr-e Riyasat by the governor, it is ultra vires. According to him, either there has to be an amendment to the Constitution of India under Article 368 and Article 370 sub-Article 3, or a fresh constituent assembly has to be convened to amend the explanation. Please mark this. This was, my lord, the contention being considered by your lordships. 22. It seems to us that the essential feature of Article 370 subclauses B and D is the necessity of concurrence of the state government or consultation of the state government. What the state government is at a particular time has to be determined in the context of Constitution of Jammu and Kashmir. Please mark this. Lord, I very respectfully heavily rely on this finding.
Yes.
The explanation did no more than recognize the constitutional position as it existed on that date, and the explanation as substituted from November 17, 1952 also did no more than recognize the constitutional position in the state. So earlier CO is also not taken into consideration. That whoever was in office was recognized by way of an explanation added to Article 367. Then number 24. The learned counsel relying upon Sampat Prakash contended that the only way of modifying Article 370 is specified in Article 370 sub-article 3 itself. He said that this was expressly laid down by this court in the decision just referred to. We are not concerned with the question whether Article 370 sub-article 3 can now be utilized to amend the provisions of Article 371 and 2, and therefore we do not express any opinion on that point. We are now not concerned with the amendment of Article 370 sub-article 1. We are concerned with the situation where the explanation ceased to operate because there was no southern areas. It had ceased to operate because there is no longer any southern riyasat of Jammu and Kashmir. If the definition contained in the explanation cannot apply to the words government of the state, then the meaning given in Article 367(4) as amended will have to be given to it. So if an authority contemplated under Article 370 ceases to exist, it can be replaced by the successor or the closest possible successor under 367.
Yes.
If this meaning is given, it is quite clear that the governor is competent to give the concurrence stipulated in Article 370 and perform other functions laid down by Jammu and Kashmir Constitution. Now, your lordships may kindly come to the last para, 26. It is true that governor is not elected as was the Sadri Riyasat, but the mode of appointment would not make him any the less a successor to Sadri Riyasat. Both are heads of the state. But I am not reading this in the context of Constituent Assembly being read in the same mechanism of Article 367 to be the legislature. Now coming back, my lord, to my submissions, my lord, written submissions, volume 3, combined written submissions, volume 3, my lords. I'm sorry, my lord, if your lordships are at the judgment, my lord, can I, only one, my lord, argument, my lord, I left, my lord. Para 28, my lord, I'm sorry. At page 47, I missed that, my lord, I should have read that. This was also an argument, my lord. A similar argument is made before your lordships by the petitioners, my lord. Therefore, I am relying upon para 28 in Damnu judgment, my lord, at page 47. Para 28, your lordship gets it. My lord justice. Yes. Mr. Garg drew our attention to clauses AA and B of Article 367(4) as substituted by CO 74 of 66. We have already set them out above. He said that this was an amendment of Article 370 sub-article 1 by the back door and the president could not exercise these powers under Article 371 when he had not purported to exercise these powers under Article 370, sub-article 3. But as we have already said, the explanation had become otiose and references to Sadr-e Riyasat in other parts of the constitution had also become otiose. There were two alternatives. First, either to leave the court to interpret the word government of the state and give it its legal meaning, or secondly, to give the legal meaning in a definition clause, that is Article 367. What has been done is that by adding clause AA and B in the definition is supplied, which the court would have in any event given. Therefore, we do not agree that there has been any amendment of Article 370, sub-article 1 by the backdoor. Just for completion, 32 on that page. It is also not necessary to dwell on the third point, namely violation of Article 21 and 22 of the Constitution, because it is clear that they are excluded by Article 35C of the Constitution. Now, my lord, coming back to my written submissions. Page 83. Again, my lord, as I had done, I'll skip what is not, my lord, relevant right now and is added only for completion. Page 83. My lord Justice Gawai, my lord, my summary, my respondents' written submissions, volume 3, page 83. Your Lordship gets that one. 17/2/1969, Article 248 was applied in a substituted form, giving exclusive power to the Parliament to make laws with respect to the prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India, or bring about secession of a part of the territory of India, or secession of a part of territory, etc., etc. Now, this is where the residuary power in a wide sphere dealing with sovereignty was given. Then your Lordships may, my lord, kindly come to page 86, my lord. 85 bottom. I am skipping 2 pages now. 85 bottom. 6/5/1972, your Lordship has taken. It further expands the residuary power of the Parliament. CO 93. CO 93, the scope of Article 248 was increased, whereby the exclusive power was vested to the Parliament to make laws with regard to the prevention of activities of disrupting the sovereignty and territorial integrity, etc., to also include taxes on foreign travel, inland air travel, postal articles, etc. Then your Lordships may, my lord, come to page 87. Lord, 28th of August 76, 42nd Amendment of the Indian Constitution come into being. Lord, what was not applied was the word socialist and secular. I have already pointed out. The word integrity was not applied and fundamental duties were not applied. Then March to July 1977, the President rule is applied, is imposed. My lord, I have given the note. My lord, please note, my lord, as a matter of fact, till 2023, Governor's rule under section 92 of the Jammu and Kashmir Constitution have been imposed 8 times and President's rule. I'm sorry, my lord, your lordships are at page 87 at the foot of the page. Till 23, Governor's rule under 92 of Jammu and Kashmir Act 8 times, and President's rule under Article 356 3 times. My lord, under 92, there is a stipulation that it cannot exceed 6 months. Therefore, then, my lord, next date, 9/5/78, 44th amendment of the Indian Constitution was brought in. The note, the non-application of the said amendment resulted in non-application of clause 4 of Article 22, which provides for major protections against preventive detention, which were not applied. This is what they lost, and this is what they started getting from 2019.
Article 22 has not been notified yet, right? So for the rest of the country, it has also not been notified as yet.
No, but it is, Malad.
Is it? 22-4 is not notified.
4 to 7 is not yet.
I'll check up. I'll check up.
What take a noise case?
But you can't issue a mandamus to notify a constitutional amendment.
Then in Article 359 related to suspension of enforcement of rights conferred by Part 3 during emergencies, the words except Article 20 and 21 inserted by 44th Amendment not applied. Hence, an absurd situation arises where in Jammu and Kashmir, even Article 20 and 21 can be suspended during emergencies, while in rest of the country it cannot be done. That's all, my lord. Emergency provision is a provision of 44th Amendment, my lord. There is, and learned friend may not feel angry about it, my lord. That's the provision which is not applied. That's the only purpose of pointing out. Then, my lord, next, 4th June 85. It modified Article 248 as it applied to the state by empowering the Parliament to make law for prevention of terrorist activities. But please see the note only, that's relevant. This indicates the government of India was taking steps to maintain law and order in Jammu and Kashmir. Notably, the modification to the union list included the term disrupting sovereignty and integrity of India. Then, some provisions with regard to scheduled tribe and in the state where, my lord, but that were in a truncated way, not for election purposes, etc. Nothing turns on that, my lord. Then 30th of July 86, my lord, page 89. The state order,
In June
this is
1985, June 1985, entry 97 was also applied, though confined to this area.
Yes. No, that was made applicable, it was expanded, my lord, it was applied in 69. 1969. I'll just, my lord, if your lordship comes to page 83, it is 17th February 1969, where entry 97, your lordship would find the first para, second line. Does your lordship get, my lord, the Chief Justice gets, my lord?
No,
Lord, page 83, date is 17th February 69,
yes.
CO 85, the first para, last line, my lord. Further, entry 97 of the union list was applied in a modified form,
Right.
dealing with the above subject.
Right.
Then, my lords,
Now we go back to your.
yes, my lord. Page 89, my lords. The said order was order issued during governor's rule. My lord, this is important, and the notes would be more important. Several COs are issued during governor's rules also. That has been a consistent practice under constitutional convention. The said order issued during governor's rule modified Article 249 in its application to the state to state that the Rajya Sabha, by passing a resolution with over two-third majority, could empower Parliament to make laws on any matter specified in the resolution, bring a matter which is not enumerated in the union list or concurrent list. So, my lord, effectively all residuary powers with two-third majority. And including state list members. And this was done during governor's rule. Come to page 37, page 90.
COs in fact were amending Article 356 because that prescribes 3 years. President's rule.
I'm sorry.
These were then extending the president rule as prescribed in the Article 356 because the period prescribed is 3 years maximum.
But it kept on being extended by the
By
parliament.
COs, it was extended from 3 to 4, 4 to 5.
It can go up to 7, Manoj, because parliament will have to then extend it. Because situation was, Manoj, it was an extraordinary situation. During that period, it was at the.
No, I'm not on that. I'm not on that. That the power to amend was excised in terms of 356, notwithstanding the provisor to
Yes, your lordships are right. That was done.
368, notwithstanding the provisor to.
Yes,
But the bodies challenged? No, they were never challenged.
no, not yet. Lord, your lordships are on page 90.
Page 9, yes, I'm on page 9.
Yes. All 4 constitutional orders were passed under the president's rule. And president rule lasted over 6 years in the state. So thereafter, I have given what Mr. Sibal has already taken your lordship through. Blue is Mr. Sibal's note, my lord, list of dates. Then, Lord, 1/3/2015, the Legislative Assembly of Jammu and Kashmir was elected and oath was administered by the members. The tenure of the assembly was 6 years, which was to expire on 1st of March 21, the last ministry. even thereafter, my lords, can we come to the next date, 6th of July 2017, CO 269, the said constitution order harmonized the tax administration of the state of Jammu and Kashmir with the GST regime operating in the rest of India. Correspondingly, entry 82 of union list was applied with modifications. Now, this ensured even economic unification, so to say. Then, my lord, 2017 is the judgment in Santosh Gupta, my lord, which I will read only 2 or 3 paragraphs, a little, yes. A little later. Please come to, my lord, page 94. 19th June 2018. The then Honorable Chief Minister resigned. Correct, Manoj? And 20th June, 2018, the governor took the decision to exercise the powers under section 92 of the Jammu and Kashmir Constitution. Now, my lord, couple of things your lordships may note at this juncture. This is appointment of imposition of governor's rule in June 2018. No contemporaneous challenge by anyone, either a political party or any elected member or any citizen, anyone. The first challenge comes after 14 months when the impugned action of 5th and 6th August 2019 is taken.
Can you invoke section 92 after Article 356 was made applicable?
No, Article 356 came subsequent. Yes, yes.
Nobody raised that issue.
But subsequently 356 comes. So if there was, I understand, my lord, the query. Even if there was an irregularity which is cured subsequently by 356. After 6
I'm still saying that.
But your lordships are right. That is the reason why ultimately I would show, my lord, the constitution of Jammu and Kashmir is required to be repealed because it can never coexist. Once you apply the entire constitution You cannot have a situation where there is a separate document of governance operating. It was, my lord, according to me, it's a separate argument, a piece of legislation, but your lordships are right. They've been directly under 356. Your lordships are absolutely right.
And Mr. Solicitor, when you say the contradiction, the very fact that you invoke section 96, 92,
92.
and not 356, you're accepting that both of them can coexist.
192, yes. Otherwise, my lord, there are several provisions which I'll be able to demonstrate. But, my lord, in any case, that's my lord, a separate submission on that, my lord. Why, how Jammu and Kashmir constitution would not exist the moment, my lord, 370 sub-article 3 is invoked. But your lordships are right.
You can argue, but other way also, there are other arguments available to make that argument.
Correct.
Or that submission.
My lord, thereafter, on 21st of November 2018, the Constituent Assembly is dissolved. Pardon me?
Legislative Assembly.
I'm sorry, Legislative Assembly, my stand correctly. Well, Legislative Assembly was dissolved. No challenge to this contemporaneously. Most importantly, my lords, I'm sorry. Today, there is no challenge to the dissolution of the assembly. The petitions which were filed after 5th and
And
6th
that
of
resolution also takes place in the Constitution of India as applicable to Jammu and Kashmir.
your lordships are.
In
Your
terms of
Lordship,
section 53.
it should have been, my lord, under 117. The petition which Mr. Sibal argued Muhammad Akbar loan is a petition filed by two members of parliament belonging to National Conference, Muhammad Akbar loan and one another member. No challenge either to the governor's rule, president's rule, or dissolution of legislative assembly. One IA is filed by the former chief minister, argued by Ms. Ramkrishnan, in 2022, IA for impleadment. Yes, I'll just double. That is IA number, your lordship wants. IA number is 154272 of 2022. 154272 of 22 in writ petition civil number 1099 of 19. That is item 501 on board, the lead petition, Shah Faisal. Now not my lord, Shah Faisal, but correct, my lords? So, no political party challenges either governor's rule or president's rule or dissolution of assembly contemporaneously. Dissolution not challenged at all. Otherwise, your lordships are aware, my lord. Your lordships are disturbed even at the middle of the night that now we are ready to forge an alliance and we are ready to form a stable government. Because there were several arguments were made on that. That how can the assembly be dissolved like that? I'm just my lord, pointing out the hollowness of that argument. But before I go further, but I must deal with one submission.
So writ petition civil 1099 of 2019 did not challenge these three things.
My lord, writ petition is by,
Did not challenge the governor's rule, president's rule, or before that.
no, my lord, I must point out, the governor's rule is challenged, but after 14 months, when
After in
5th and
1099.
6th of August 2019, when that was, must be being drafted, it must have been advised that you have to challenge the main imposition. That appears to be the case.
So the governor's rule was challenged.
Challenged after 14 months,
Then obviously the president's rule would have been also challenged.
yes,
It's bound to be, bound to be.
yeah,
And
bound to
the-
be.
And dissolution of the legislative assembly is also challenged.
Is not challenged,
Is not challenged.
is not challenged, still not challenged. In any of the petitions till date.
Till now, none of the petitions is challenged.
Yes, none of them.
And that's in terms of section 53(2).
Yes. And, my lord, the petition argued by Mr. Sibal, which was which is number 1099, loan, Abdul,
That was 10.
Muhammad Abdul loan, my lord, which was by NC, my lord, National Conference. Not even president's rule or governor's rule under challenge. Well, I have a list, I have the list, my lord. I'll just show that list, my lord, to your lordships. Where is that list?
True of fact, what is the governor's rule was challenged through a PIL filed in this court, dismissed. There was a PIL filed in this court, challenges governor's rule, was dismissed by Justice Gogoi.
I'm
And
coming
I'd be
to-
very happy if this court were to say that because all this was not challenged, the entire process that is adopted is constitutional.
Where did I argue that, my
I'd be
lord? Why
very
the
happy,
learned friend?
very happy if this court were to say that.
My lord, where did my learned friend, my lord, why is he presuming what I'm going to argue?
Since you are talking about it.
No, I'm talking about it because half an hour of a political kind of an argument was made. How can you dissolve the assembly like this? What are the powers of the governor, etc.?
Constitutional bench of this judge, of this court has said you can't do it.
Correct, but you can't argue it without the challenge.
I have never made a political argument in this court and your lordship knows about it. Not a single political.
Lord, if there is no challenge and if you raise a plea that there was, the governor should never have dissolved, it becomes a political argument. It's not an argument based to suppress.
But taking your point that Mr. Sibal's writ petition, there was no challenge to president's rule, governor's rules or the dissolution.
Yes, and dissolution not in challenge in any of the petitions.
That we've got.
So, my lord, that question your lordships need not go into. That's the my lord, respectful submission. And my learned friend is right. So please, if you don't mind.
Paper book 501.7, in fact, their counter affidavit has a listing of all the prayers of all the
I
petitions.
was going to say that, please allow me. I have prepared a list and place it, my lord. This is the submission in support of my lord, plea that your lordships need not go. Because a substantial time was consumed on this argument. Therefore, my lord, I am my lord, laboring this point that it was not necessary. My lord, please come to my lord, volume 501.7, paper book 2993. My lord, the prayers are quoted.
80?
Which documents file are you saying?
Which document?
Paper book.
The main paper book, my lords.
1.7.
Seven.
Page?
Page 2993. Why would I not point out something which is in my favor and I have placed with my reply?
Folder. 2993. There's various item numbers.
Incorporated all the prayers with writ petition numbers. Yes, sir.
2993 is a.
2993, my lord, is the page number. PDF page 2993. Your lordships have seen the chart. These are the only prayers before your lordship. And that too after 5th and 6th of August 2019, after 14 months. And I have, my lord, also narrated a chart showing the pleadings also.
But we have petitions where everything is challenged except the dissolution of the Legislative Assembly.
Correct. No, my lord, there are petitions.
There are petitions challenging the imposition of governor's rule, the imposition of president's rule, and but according to you, no challenge to the dissolution of the Legislative Assembly.
Correct, my lords. But one factual clarification. In some of the petitions, even that the governor's rule is not under challenge. For
There are some petitions where there is.
Yeah, yes,
So
but
we'll
some
have to deal with it
petitions
anyway once it is raised.
to
Even in
have a challenge to governor's rule.
But governor's rule was challenged in most of these petitions post the president's rule.
All the petitions post the decision. That is why
Except what Mr. Sibal said, there was an earlier petition filed which was discussed.
yes, my lord, that's what, my lord, I have pointed out, my lord, in my summary of submissions, my lord. Please see, my lord. That is, my lord, at page.
If there were no actions on 5th and 6th, we won't be here. We wouldn't have challenged anything. We are challenging the actions under those provisions.
No, let
That's all.
Mr.
I'm
Sibal.
just saying. we wouldn't
No, I am also, whenever interrupt, I am just saying, but don't do that. That's why the rejoinder stage is always there. I understand your discomfort, but what can you do? What can I do?
I mean, I understand you.
Lord, PIL. Not PIL, it was not a PIL. I'm sorry, it was not a PIL. My learned friend, my lord, possibly not correctly briefed. It was a PDF 250, take my lord, PDF 250. I have, in my written submissions, my lord, I have done this. One MLA challenge, it was not a PIL. Please see, my lord, the order of this honorable court. And kindly have a look at, my lord, at PDF 250.
Same paper book.
Yes, my lord.
Which paper?
No, I'm sorry, volume paper. No, I'm sorry, written submissions paper.
You are taking us back to volume 3?
No, my lord, the same volume 3 of written submissions.
That's what I'm saying.
Yes, there, PDF page 250. This Gagan Bhagat was not a PIL petitioner, he was an MLA. We argue, anyway, my lord, we learn from my lord, senior, my lord, I will not say anything more than that.
Yes, I know.
I am only arguing a matter, my lord, I have no political,
Yes, let it finish, tell me.
My lord, I have nothing, this is a constitutional point for me. Your lordship gets that order, my lords?
This was a petition challenging precedent's rule.
Yes. No, this.
Governor's rule.
This was dissolution, I'm sorry, dissolution,
This was against what, challenging dissolution or the governor's rule?
dissolution,
Dissolution.
dissolution.
Therefore, they've not included that prayer in any of these petitions because that has attained finality.
But that's what they came to know when I say in my written submissions. They were not aware of it. They have not mentioned that we have not challenged because it is affirmed by the Supreme Court. I'm sorry, ma'am. The lordship said that we have heard, we have seen the record, and we dismiss the petition. Therefore, I am not going into the details. Otherwise, my lord, I can show details also. But there are reasons, my lord, why it is not challenged. My lord, when you don't have a case on the floor, you don't challenge it. That's as simple as that. But let's not go into it. Why they have not challenged it? It's definitely not because this petition was filed and dismissed. Because none of the petitioners say that this petition was filed, heard by this court, and dismissed, and therefore we are not challenging it. They came to know possibly only when I pointed out in my written submissions. So far, it was not on record. Now, Lord, page 95, 1912-2018. Lord, proclamation under Article 356.
Yeah.
Lord, here, my lord, I must answer one question. Lord, suspension of proviso to Article 3, my lord, that was an argument. Lord, there are two arguments. The argument was advanced with a nuance that this was a device to bring certain legislative enactments or certain parliamentary actions by suspending the provisions of the article, the proviso to Article 3, namely the reorganization. Like that was the allegation. Correct, my lord? Your lordship recollects that. As a matter of fact, right from the inception of this country, whenever President's rule is imposed, proviso to Article 3 is stayed. We have studied each and every proclamation issued by the President under Article 356 with regard to each and every state, not Jammu and Kashmir. Proviso to Article 356 is suspended in every case. And please have a look at, my lord, the chart which I have, my lord, placed at page 227 of this very file, my lord, of this very volume. as if we did something surreptitiously because some sinister plan was in the mind. This happens right from the inception. The first president rule was in Kerala in 1957. Since then, my lord, we have studied, and my lord, we have the learned AG also has the volume, my lord, if your lordship would like to see that. But I have said so. So please come to page 227 of this very volume, my lord. Two 26 minutes. Now, please see, Andhra, Arunachal, Assam, Bihar, Goa, everywhere, my lord, suspended. The lordship would come to page 9, clause 9, erstwhile state of Jammu and Kashmir. Twice, 86 and 90. On both the occasions, the proviso to section Article 3 was suspended. There is a reason, my lord, why this format is used. It's not to do something surreptitiously. Lord, in SR Bomai, the law laid down, and I'll come to that, the law laid down is that the legislature cannot function without Council of Ministers. When that is the position here, additionally, the legislature was dissolved, but otherwise also, whichever provision of the Constitution mentions something to be done by the legislature, that provision is suspended. That's the format to be used, being used from the beginning. 1977 was the first use of 356, 59, I'm sorry, 59. Mr. Nambudripad's government was removed and the president's rule was imposed. That was the first and perhaps the most controversial imposition of president's rule. There also suspension of 3 proviso was there. We have the notification if your lordship would like to see that. The first use of 356. This is the idea. This is the purpose. Whichever constitutional provision says use of some legislative act by way of making law, by way of views, by way of recommendation, those provisions stand suspended during president's rule. It was not with a view to do something which they claim to be a fraud on the Constitution. That's the respectful submission. Now coming back, my lord, to page 95. Lord, once the president's rule is imposed, your lordships are aware Article 356 requires that it needs approval of the parliament. Both the houses will have to approve it. Lord, last but one date, 28th December 2018. A resolution approving this proclamation issued by the president on 1912 was passed in Lok Sabha. I have given, my lord, my counter affidavit's number. This is not a fact in dispute. 3rd January 2019, approving this proclamation issued by the president on 19/12/2018 by Rajya Sabha. Correct, my lord? Now, my lord, during the president's rule, there are certain steps taken, my lord, with a view to infuse confidence amongst the people. My lord, there were situations, my lord, which were alarming situations. Everything won't come on record. Pulwama happened in February 2019, etc., etc. And the government will have to take certain proactive steps. Now, that first step is 1st of March 2019. But this is a well-considered administrative decision-making, keeping in mind several factors: national integrity, sovereignty, security, border issues, internal issues of the particular state, etc., etc. Please see, my lord. Using the power under Article 371D, CO 271 was passed, which extended, my lord, please allow me to delete 61st Amendment. My lord, that's a mistake. And kindly, my lord, delete in your lordship's copy also. It was applied earlier. Nothing turns on that, my lord, either way. It is a simple mistake, but just to put the record straight. Then 77th Amendment and 103rd Constitutional Amendment, providing for a reservation in favor of economically weaker sections of Jammu and Kashmir and for providing reservation in promotions. Now, please note this. It may be noted that this was during the currency of President's rule, similar to impugned CO 272. However, the same has not been challenged till date. Further, the power under Article 371D to issue CO has been exercised during President's rule on 6 occasions in history. The note 1. The extension of this amendment, my lord, this is the relevance. Please note this, my lord. Something may turn, something may not turn, but it may satisfy a lordship's conscience. The extension of this amendment to the state reinforces the fact that in terms of social justice policy of reservation, the state of Jammu and Kashmir is governed by Constitution of India. Acceptance of social policy of the Union further means that Jammu and Kashmir does not and did not have a sovereign right to determine the social policy at odds with that of the Union. Thereafter, my lord, President's rule is extended on 22nd July 2019, and thereafter please directly come to page 97. But one fact, my lord, from Mr. Sibbal's notes, my lord, I may show. Mr. Sibbal, my lord, in blue, has said that several questions were being put to the minister. Are you going to change 370? Are you going to take some steps? And the minister concerned, my lord, used to say that we'll act according to the Constitution. That's all. But please see, my lord, just above 28th of June 2019, the question is put post Pulwama and the answer, my lord. Please see this. The question, Srimati so-and-so, 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 ask question number so-and-so, 1. Your lordship gets, my lord? Charging, my lord?
Referring to page?
I'm sorry, my lord, page 97. Lord, but for this, Lord, e-filing, but this kind of matter, my lord, it was very, almost impossible, my lord, to effectively argue.
Other way, just turn it around. No? Yeah.
Lord, page 97, date 26th June 2019, from my learned senior Mr. Sibbal's Lord note. Srimati so-and-so, so-and-so asked question number 485 from the Minister of Home Affairs as to A, the viewpoint of the government regarding Article 370 and 35A in respect of Jammu and Kashmir. The policy government is working on to control the terrorist activities and details thereof. Then Sri Reddy, my lord, MOS Home. At present, Article 370 is a part of Constitution of India. Under the title Temporary Provisions with respect to the state of Jammu and Kashmir, and Article 35A is contained in the Constitution, application of Jammu and Kashmir Order 1954, issued by the President under 370. B and C. The government has adopted a policy of zero tolerance towards terrorism. Effective response is given by security forces to counter terrorism activities in the state of Jammu and Kashmir. In order to combat activities of terrorists, several steps have been taken, including strengthening operational grid, enhancing coordination among security agencies, effective retaliation of terror acts. Please mark this, brother. And this comes, my lord, immediately, strengthening the ROP to protect convoys, etc. Correct, my lord? I leave it at that, my lord. I don't wish to elaborate it further. My lord, since the president's rule was extended, my lord, it had to again go for approval. Both the houses, my lord, respectively on 28th June and 1st July, my lord, approved the extension of the president's rule. Now comes, my lord, an important event. Again, my lord, to ensure that those who are staying in border areas are having a sense of security, social security. 1st July 2019, it is critical to note that on the same day, Jammu and Kashmir Reservation Amendment Act was passed by the Parliament, exercising powers as the legislature of Jammu and Kashmir. Your Lordships have seen Article 256 1B, that when President's rule is there, the Parliament exercises the powers of the legislature. This enactment was passed. Considering the strategic and security concerns in mind, the Jammu and Kashmir Reservation Amendment Act was passed by the Indian Parliament. This fact is mentioned to show that, like in past, the Parliament has exercised legislative powers of Jammu and Kashmir Assembly under Article 356 1B. Prior to, this is important, prior to the aforesaid act, some category of reservation was available only to border areas of Kashmir division. Border areas of all divisions, that is Kashmir, Jammu, were facing frequent attacks and shelling, and resultantly more hardship. Regimes prior to 1/3/2019 somehow confined the reservation benefit to borders areas of Kashmir division only. Lord, there are several steps which are required to be taken in view of several circumstances which the nation faces. And these are the steps as precursor. Lord, kindly see now PDF page 229 of this very compilation. Lord, I have said that this has been the practice and the constitutional convention throughout. Whenever there is a precedence rule, the Parliament exercises the power of the legislature as contemplated under Article 356 1B in all states.
Yes.
Lord, page 229. I'm not reading, but I have taken, my lord, till date, whichever are the acts passed by the Parliament, acting as a legislature of the state during President's rule, the list is given, my lord. But there are total 248 such laws passed, my lord.
Happens. 248 laws.
Lord, just go to 242. I'm sorry, 243. Lord, there is something which would, Lord, require your Lordship's attention, Lord. 242, Lord, I'm sorry. At 243, Lord. Look, this is, I'm showing in case of Punjab. Look, the most important part of any legislative transaction is passing of the budget. Budgets are passed by the parliament on behalf of the states, acting as a state legislature. To Malod, the important part, 243, and I'll point out, Malod, what is the relevance of showing this. In case of Punjab, your lordships would find item number 31, the Punjab Reorganization Bill. Your lordship gets that?
Yes.
My Lord Justice, 240. But during the President's rule, the Parliament acting as the legislature even reorganized the state of Punjab. Something which happened here, my Lord. Lord, Punjab was divided, bifurcated into Punjab and Haryana. Chandigarh was carved out as union territory, and some part of erstwhile Punjab went in Himachal. These were the four bifurcations, my Lord, which took place by Punjab Reorganization Act passed by the Parliament acting as a legislature. So, my Lord, it is not uncommon or it is not something which has happened for the first time that you can elevate the argument to the level of a constitutional fraud.
But this must be a reorganization act under Article 3.
Yes, I'll come to that, my Lord. I'm coming to, because I'm right now, my Lord, pointing out that suspension of proviso to Article 3 is not unusual. Whenever provision is suspended and precedent rule is also imposed, the Parliament acts as a legislature. My Lord, and this, my Lord, when I make my submissions on Reorganization Act, I'll, my Lord, also point out this Reorganization Act was challenged on this very ground before Delhi High Court.
Yes, Punjab.
Yes,
Punjab,
Punjab
Haryana.
judgment. My Lord Justice H.R. Khanna's judgment. And it was also challenged before this honorable court and Mangal Singh, I'll point out 5-judge bench judgment. This very Reorganization Act. Now coming back, my Lord, I'm sorry.
Yes.
Lord, kindly come to 10. Lord, before I take, Lord, now, my Lord, I'm on the last leg of this written submissions, my Lord, namely,
But Mr. Solicitor, if the powers of the legislature of the state under 356B can be exercised by Parliament, then what is the constitutional necessity of suspending the proviso to Article 3?
so that legislature, if present, if not dissolved, may not do anything. But this is, we are dealing with a case where the legislature was dissolved. But suppose it is in suspended animation. The legislation remains, the legislature remains. It might assemble and pass a resolution.
To be very frank, except in the case, possibly the case of Punjab, I don't think Article 3 would have been invoked in many other cases. But as a matter of convention, what has been happening is whenever 356 is imposed, going by your submissions, proviso to Article 3 is also suspended.
Suspended.
Because the power under Article 3 is different from the power of legislation.
Correct. No, my lord, my lord, point out, 356, my lord, kindly, just taking a
That's
little
what was
detour.
highlighted was power under Article 3 is different from the power of, which is conferred of making legislations, making or enacting laws.
That's where, my lord, I would like to say something, if your lordship takes 356, taking a slight detour, my
No,
lord.
it says to calls about functions.
It says the powers of the legislature. Powers of the legislature.
Powers.
No, not just powers to make laws,
Correct, it's broader, it's
All
broad.
powers.
all powers, and now please see proviso to to Article 3. Proviso to Article 3. Provided that, I'm sorry, sir. Yes, sir. Provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon. This is the different power of the legislature than power to make laws. So even this power in the present case was exercised by the parliament. Now, my lord, before I take, my lord, the last leg of my.
Otherwise, in the absence of the suspension of the proviso, what would happen was that the parliament is exercising all the powers of the legislature of the state. It would give its views on it, and it would also enact the bill.
Yes, ma'am. Yes, ma'am. That's the constitutional.
So that's your answer to the challenge that there's duality is missing in this case, because you say when Article 356 is invoked and we have been, and the proviso is suspended, there are instances in the past wherein it was, this argument of duality was rejected.
Yes, my lord, I can, my lord, take directly your lordships to.
Or we come to that, you go in your own way.
No, otherwise, my lord, Justice H.R. Khanna's judgment on this as a Delhi High Court, my lord, in Delhi High Court is directly on the point. And explanation and my lord, the interpretation of Article 3 by a constitution bench in Mangal Singh, that also, my lord, concerned Punjab. This very reorganization, which was under 356 and the power exercised by Parliament as a legislature.
Has to be.
But in Punjab, incidentally, even views were not taken of the Parliament as a legislature, saying that the assembly is suspended. So straightway, the reorganization bill was passed. As a reorganization, my lord, this is interesting, and I'll show that judgment. What happened was, in the erstwhile state of Punjab, my lord, for example, there were 85 seats of MLAs. Now some portion goes, so 85 became 70. The remaining 15 challenged them. That how have you taken away our right to continue as members of the Legislative Assembly? And the number was lower than even minimum prescribed for any assembly to have. And then the question arose about Article 4, that you can make incidental provisions which might even amount to amending the Constitution but would not be treated as amendment of the Constitution. Constitution bench of your lordship. But since, my lord, we are on this, let me, my lord, show Justice H.R. Khanna's judgment, my lord, because your lordships have just seen Article 356 and Article 3. My lord, kindly have a look at, my lord, Volume 1, my lord, compilation Volume 1. That is a separate argument, but at this stage, my lord, I'll just show these two judgments, my lord, just to. Lord, it's marked, my lord, in my written submission also. Lord, it's easier, but rather than going to page 167 of this very compilation, my lord. A very,
Now you are back to the original one.
written, yes, my lord. So that, my lord, your lordship may not have to shuffle through. Yes. Lord, what I have done is, for your lordship's convenience, I have quoted the para. Of my written submissions, my lord. That is joint written submissions, volume 3.
'67, right?
167, my lord. On reading Article 3 and Article 174(1) of the Constitution, along with above proclamation of the President, it is seen that the President had suspended the power of Governor to summon the House or each House of Legislature of the state, which by itself prevented the state legislature from meeting, and also suspended the state legislature from meeting, and also suspended so much of proviso to Article 3 of the Constitution relating to the reference by the President to the legislature of the state. It will thus be seen that the power to summon the legislature of the governor having been suspended, no occasion could thereafter arise during the period when such suspension was in operation for the legislature to meet for the purpose of expressing its views on the bill. Here it was dissolved. The bill to be introduced in Parliament affecting the area, boundaries, or name of the concerned state. This would be the direct result of the suspension of the power of governor to summon the legislature of the state, even without suspension of so much of the proviso to Article 3 relating to the reference by President to the legislature of the state. However, in order to make the matter clearer, the operation of so much of proviso to Article 3 had also been suspended by the President. In view of the clear power conferred by Article 356 1AB to declare that powers of the legislature of the state shall be exercisable by or under the authority of Parliament, it enacted Act number 31 of 66, by which all powers of the legislature of the concerned state, state of Punjab, to make laws were conferred on the President. We can find no warrant for the contention of the petitioner that what was transferred by means of Article 356 1B of the Constitution was only the legislative power of the state legislature, but not the power to meet and express its views as contemplated by the proviso to Article 3 of the Constitution. But as my lords pointed out, that the word power is wider, which includes power to make law, but all powers, give recommendation, expressing views, etc. 3 of the Constitution. According to the petitioner, Article 356 1C only enabled the President to make such incidental and consequential provisions as appeared to him to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provisions of the Constitution to any body or authority in the state, but not to make provisions which were not both incidental and consequential. This was one of the contention. This argument of the petitioner would appear to have no validity for two reasons. Firstly, the expression incidental and consequential may be read as incidental or consequential to suit the context, that this is a permissible mode of construction if the context so requires. It is well settled. It will be sufficient to refer. Then the judgment is when N can be read as, or your lordships may skip. Para
Mr.
10.
Solicitor, you have referred to the fact that there's a practice, a constitutional practice that during the operation of a proclamation under 356, the proviso to Article 3 has been suspended. And you have said that that is obviated by the reason that if you don't do so, and the legislature is only in a state of suspended animation and not dissolved, the legislature may conceivably meet to express its view. To obviate that, Parliament, the presidential proclamation does this. But none of this constitutional practice cannot obviate the legality of what is done, right?
Here, in the present case, even the views are taken, but views are given by the Parliament as a legislation. In Punjab, that was not the case.
So Parliament would then give the views
To itself.
and it would also enact the legislation for reorganization.
Yes, but that's the inevitable consequence.
But would that really be consistent with the federal
I will
document?
show that. I will show that. Manoj. It does not destroy federalism at all. I'll be able to satisfy your lordships. I'm just, Manoj, since we are discussing this, I have not taken up the point of state reorganization.
All right, but you're saying that
Yes, but since we were answering, I was answering the proviso to Article 3, which came with 356, Manoj, I'm reading this. Jen.
all right.
Para 10, Manoj. It can hardly be denied that the dispensing with the need to consult the views of concerned state legislature was itself a direct consequence of the legislature being unable to meet for any purpose whatsoever during the period when governor's power to summon the legislature was itself suspended. The petitioner does not advance his case in any manner, therefore by laying stress on the expression incidental alone in Article 356 1C. Secondly, the petitioner cannot seek to derive any assistance from the English decisions which he quoted in order to show that what he contended was the restricted meaning given to the said expression, etc., etc. It could even have been
It's, it refers to the earlier incident in the case of erstwhile state of Travancore and Cochin, probably also under 356. May not have been challenged in that case.
not to my knowledge, my lord, it was not.
Paragraph 95 it refers to.
Paragraph, my lord, my lordship, sir.
5.
Novel situation has been taken place in past. Punjab was passed. Further, the erstwhile state of Travancore, Cochin was also reorganized during Article 356. Lord, in both the cases, the views were not taken.
Possibly it takes into account sometimes there may be a breakdown of constitutional machinery within the state when the reorganization itself
Is the solution. When there is a, my lord, kindly appreciate, my lord, by this, my lord. I'm sorry, not kindly, my lord, consider this. Lord, when the reason for imposition of the precedent rule is such that to bring that state out of the situation which resulted into imposition of precedence rule, maybe state requires to be reorganized. Then, my lord, the position cannot continue as it is. The President of India can take a call that the only solution of the problem is reorganization of the state. And your lordships are, my lord, the arguments repeatedly advanced was that there is a retrograde step. We were brought down from state to UT state. I will show, my lord, from the reorganization. It's a state for all purposes. It's a state with legislature, with only power of police with the president. It's a detailed state reorganization. Everything was factually wrong, that my consolidated fund has gone, my representation in parliament has gone, my election voting in president's election is gone. Specific statutory provisions are made. GST council is gone. These are the arguments which were. So I am coming to that reorganization. The UT, my lord, is essentially as much a part of federal structure as any other state. In a given set of facts, Lord, your lordships have, my lord, I don't want to jumble up, my lord, my submissions, but there are, my lord, submissions. What would be the contours of your lordship's examination once your lordship finds that 356 exercise was not to be faulted with? what happens thereafter, there would be a restricted scope of judicial review. That's what Bombay has said. It's a narrow compass doctrine. No? Your lordships are aware. My lord, I'll take your lordship through them. But here, to obviate that also, the views of the parliament situations where it is necessary that for some time this remains under union as union territory. And the Honorable Home Minister on the floor of the House has said that this is a temporary measure. Ultimately, it will become a state. But that's a separate argument. But I'll come to that. Lord, now I may, my lord, complete, my lord, my written submission, my list of dates, my lord.
What page?
My lord, I was at page 102. My lord. But before that, my lord, I wanted your lordships to read one judgment. My lord, 102. Let me, my lord, complete this stepwise, my lord. My lord, step 1, your lordships have seen, my lord.
No, we were going to read that actually, right? We were just going to read that actually.
Yes. No, your lordships are at step 1, my lord.
We are now at step 1.
Yes. My lord. Please see, my lord. As a first step, the Honorable President issued CO 272 by the said constitutional order issued under 370 subarticle 1, that is D. The President applied all provisions of the Constitution of India and superseded all previous constitution orders by which selected provisions of the Constitution of India were made applicable either with or without
Which is
modifications.
this one second.
I'm sorry, my lord, Justice Colgate, my lord.
Point number 1.
Point number 1, step number 1. As a first step, the Honorable President issued CO 272 by the said constitution order issued under Article 370 subarticle 1. The President applied all provisions of the Constitution of India and superseded all previous constitution orders by which selected provisions of the Constitution of India were made applicable either with or without modifications. And 2, the Honorable President applied Article 367, your lordships have seen it has been applied 4 times in past, of the Constitution of India as modified under the said order in which modification was made in Article 367, sub-article 4. Please see, my lord. At D. This is the exercise which is, my lord, approved in Damnu. D. In proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the State referred to in clause 2 shall read Legislative Assembly of the State. This is the first step. My lord, when I explain this, my lord, I'll assist your lordships that in absence of an assembly, Constituent Assembly, my contention in law is that the President is free to take a call, even without recommendation, but I'll come to that little later. Step 2. After having applied the entire Constitution with modification as stipulated in 367(4)(d), as reflected above, because we had to, my lord, save 367 because that's the mechanism we have used. Reflected above, the Parliament after CO 272 was placed before it undertook the following exercise in its capacity as the legislator of the state. Then, my lord, Rajya Sabha recommended to the President under Article 370, sub-article 3 as under. Now Rajya Sabha as a legislative assembly recommends, please see my lord the bottom, that this house recommends the following public notification to be issued by the President of India under Article 370 sub-article 3. Please see my lord the next para. All provisions of this constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or Article 308 or any other article of this constitution or any other provision of the constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged in the Article 363. Or simultaneously, on bill being sent to Rajya Sabha under proviso to Article 3, Lord, which according to me, I can safely argue not necessary in absence of the legislature views. I'll show the Mangal Singh judgment. But it was placed before the Rajya Sabha as a legislature, first step of legislature, because second is Lok Sabha. Rajya Sabha expressed its view to accept Jammu and Kashmir reorganization bill as under, that the President of India has referred the Jammu and Kashmir reorganization bill to this house under the proviso to Article 3 of the Constitution of India for its views, as this house is vested with the power of state legislature of Jammu and Kashmir as per proclamation of the President of India dated 19th December 2018. This house resolves to express the view to accept the Jammu and Kashmir reorganization bill. Simultaneously, on the bill being sent to Rajya Sabha under proviso to Article 3, the President, the Lok Sabha expressed its view. After Rajya Sabha, Lok Sabha, so that it whole becomes the legislature. They also, my lord, accepts the thereafter, my lord, Rajya Sabha passes Jammu and Kashmir Reorganization Act 2019 after views of, my lord, both the houses. Now, your lordships may skip the note and kindly come to page 106 bottom. Next day, 6th of August 2019. The lordships have seen, my lord, the recommendation of the Rajya Sabha acting as a legislature under Article 370, sub-article 3. Now it comes before Lok Sabha. On 6th August 2019, again the Parliament commenced its proceedings, exercising its function as Legislative Assembly of Jammu and Kashmir. The following legislative activity took place. Lok Sabha recommended to the President under Article 370, sub-article 3, let's say, I'm not reading it, recommending to the President that you apply all provisions of the Constitution as was recommended by Rajya Sabha. And Lok Sabha passed Jammu and Kashmir Reorganization Act because the views were expressed the previous day. So both the views and act, it becomes an act, namely Jammu and Kashmir Reorganization Act, and both the recommendations which now culminates into, Lord, 263, CO273, I'm sorry, 273. Lord, please see page 108. Further, in the appendix to the bill, a comprehensive schedule contained the list of central laws made under the Union list and the concurrent list by the Parliament, which would henceforth be applicable to the Union Territory of Jammu and Kashmir and Union Territory of Ladakh. The amendments have also been carried out to the existing state laws made under the state list by the erstwhile state legislature in order to bring them in line with all provisions of the Constitution of India. So they become now Constitution compliant. It is critical to note that the said Reorganization Act applies an already existing constitutional provision, that is Article 239A to the region. It is stated that the same counters the assertion of the petitioners that it was in breach of federal structure. It is stated that Article 239A itself is a part of federal or asymmetrical federal structure and cannot divorce the concept from the landscape of Indian constitutional law. Article 239A, applicable to Puducherry for decades, is one of the ways of maintaining federal relationship between region and center and cannot be said to be arbitrary and irrational. Well, then step 4 and the last step, CO 273. President issued CO 273 in exercise of powers under Article 370 sub-Article 3 of the Constitution as amended by CO 272, declared that Article 370 would cease to apply with effect from 6/8/29. This is what is impugned. Thereafter, my lord,
Mr. Solicitor, this may
वो ऊंचा होता है ना, कई
be
बार
your
मैं
answer
phone
as far
रखना
as
होता है।
Ladakh is
It's okay,
concerned,
कोई नहीं। I'll
but
manage.
converting J&K into a union territory,
हाँ, मैं इधर करके
what is
दिखा
being
रही हूँ।
argued by the other side is downgrading.
I must meet with them.
That argument, number one. Number two
थोड़ी सी इधर मेरे वाल कर।
is Article 356, the maximum tenure as prescribed is 3 years.
Welcome to Kunli TV.
We have crossed those 3 years.
At the time of, my lord, I'll answer that, my lord, but 2019 we have not. And thereafter, my lord, we are in a different regime.
No, I know. Now, as a union territory, that 356, that part will not apply because union territory is something different.
Is, my lord, therefore, my lord,
But if it was not a union territory, then
it
that
would have crossed. It would have crossed by now. But for the intervention of 5th and 6th August 2019.
yes, that's
Yes. Lord, for your lordship's convenience, I have prepared, my lord, a chart. This is only section and the article and how it changes. It would be for quick reference, my lord, if your lordship permits. It's not nothing new. Nothing new, my lord. But 367 application, my lord, is little confusing if we read from various pages. Therefore, my lord, we have just made a common kind of a 3-page chart.
as far as 367 is concerned.
Only 367.
367, because there was some deletion also in 367.
Therefore, my lord, please, my lord, it won't take more than 5 minutes, my lord. Kindly pardon me, my lord, this, I think, better to have the physical copy, my lords, because it's larger. Lord, left-hand side is the Article 370 as it stood on the date of Lord, Constitution coming into force. Correct, my lord? Right-hand side is as on 17/11/52, CO 44. My lord, the change made under 370 sub-Article 3. Please see the color part. My lord, your lordships, I think, my lord, the Chief Justice is ahead of me, my lord.
Yes. the
Yeah,
first-
always so, my lord, but even
No,
in
but-
this chart. my lord.
Explanation, right? Explanation.
Explanation, for the purpose of this article, the government of state means, Lord, this is replaced by Sadr Riyasat. Please see.
Right.
Person for the time being recognized by the president on the recommendation of the Legislative Assembly as Maharaja of Jammu and Kashmir, acting on the advice of Council of Ministers for the time being in office under Maharaja's proclamation dated so and so. The person of for the time being recognized by the president on the recommendation of the, this is edit, the green part is addition, my lord. Green part, kindly, my lord, if your lordships can consider writing green part is addition. But please mark one thing, though, my lord, at that date, 17/11/52, the Constituent Assembly was in place. In 52, Constituent Assembly was in place, but only Legislative Assembly, my lord, was used while defining the state.
Right.
When there is a state legislative assembly of the state, president on recommendation of legislative assembly of the state as Sadr-e Riyasat of Jammu and Kashmir. This is the first change.
But this was done pursuant to the recommendation given by the Constituent Assembly.
Correct. I've said so, my lord, in my written submissions as well. My lords are right. Thereafter, my lord, page 2, Lord, this is as on 14th May 54. The second change takes place.
Just one, this would be, this amendment which came as a result of, this is under Article 370, Clause 3. or-
First
The first exercise. of
First
370.
exercise.
This is under Article, Clause 3 of Article 370.
The first one, yes.
Because at that time Constituent Assembly was there.
Was in force.
So they then, the
Recommended.
recommendation resulted in the amendment to the constitution, it got carried forward. Words which are not pre-consent, pre-recommended.
May 1954, that is CO 48,
Yes, my lord. The entire green part is added, my lord.
under Article 367.
Yes, my lord. My lord, only D we have highlighted in yellow to, my lord, show to your lordships, my lord, I have already emphasized that reference to the legislature or the legislative assembly of the state shall construed as including reference of constituent assembly. So inclusive definition. So they were used interchangeably. Otherwise, my lord, this entire green part is added in 54 and its effect is given, my lord, on the right hand side.
Right.
It is the same thing and therefore I am not reading it, my lords. I have given the effect of the 367 exercise. Then, my lord, coming to page number 3, it is again, my lord, under 367, where D, your lordship would find in red is deleted. Correct, my lords?
Right.
The reference to legislature or the legislative assembly is deleted and, my lord, green is added. What is deleted, my lord, is in red. Raj Pramukh reference goes, my lord, in 58 because of, I have pointed out, Reorganization Act, etc. and, my lord, Article 238, my lord, being repealed. Reference to a governor shall include reference to the governor of Jammu and Kashmir, provided that in respect of any period prior to the 10th day of April 55, such referendum that is for the past period. So now now comes the governor because Sadr-e Riyasat ceases to exist and therefore the governor. Right hand side, I have given effect to this amendment.
CO 56 came in after the constitution was framed in
Correct.
Jammu and Kashmir, after 26 January 1957.
My lords are right.
So therefore, the reference to the Constituent Assembly is done away with in the
Deleted.
Article 367
Deleted.
interpretation.
But exercising the mechanism under 367. That's the, Lord, I wish to highlight. Otherwise, that's the two reasons. A, Constituent Assembly was not there and governor because of state reorganization. Now, my lord, AA is the new addition. My lord, this is 66. My lord, this is the left-hand side on page 4 is what Damnu judgment, my lord, approves. That 367 can be used for this purpose. AA is addition, reference to the person for the time being recognized by the president on the recommendation of Legislative Assembly of the state as Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the governor of Jammu and Kashmir. And, my lord,
But Sadr-e Riyasat had already gone, right?
yes.
So then what is the need for bringing this in 1966?
No, I'm sorry. Sadr-e Riyasat went here.
Oh, it went
I'm
here,
sorry,
that's
it went
right.
here. Earlier, it was removed from B, 4B. I'm sorry, B, it remained, it went in E. E. Now it goes from B as well.
Earlier, the amendment was Sadr-e Riyasat acting on the advice of the Council of Ministers. Earlier, it was individual capacity, then it became acting
Yes.
on the advice of Council of Ministers. Here now, the Sadr Riyasat is replaced by governor.
Governor acting on the aid
Right.
advice. Yes, my lord. Now, my lord, the last one at page 5, Lord, which is done by CO 272, the impugned one, my lord, page 5. The proviso is added. The exercise which was undertaken so far under 367 was again undertaken for the purpose of Jammu and Kashmir. For Article 370, the word Constituent Assembly was replaced by the word Legislative Assembly. Same thing, because Constituent Assembly ceased to exist, it became Legislative Assembly now. And, my lord, the rest, I have, my lord, already explained. Tomorrow. There was one request, my lord, if it's a more of a, my lord, convenience request. My lord, if your lordships were pleased to sit on Monday, my lord, if your lordships can consider sitting even on Friday, maybe, my lord, it might be able to, we might be able to, my lord, finish.
Your whole site can wrap up then
Yes.
completely. So that then.
Because there is
Monday-
one holiday, that's, my lord, the request, my lord, if it suits your lordships and the other side, my lord.
By 1 o'clock on Friday, we'll give you up to 1 o'clock on Friday.
No, I will finish tomorrow.
No. You means your side, so that you can all.
I can't
You are
say
saying
about
until 4 o'clock. You are only saying if you can all finish by lunch on Friday, then there's no difficulty. We can sit on Friday, but all of you can try and finish upon. No, you have to do it. I know you, but now it's going to be repetition because by next Tuesday we want to give them 2 days in rejoinder. Mr. Giri, otherwise this will go sometime to September. The bench may not be available for 10 days, 12 days. You don't want to take a
Keeping
break.
that in mind, my lord, I am requesting for Friday.
What was session on Monday, might be?
No. We will not, we'll wrap up on Friday.
Or Thursday?
Lord, in fact, we have bifurcated the subjects. My lord. There may not be much of a duplication, but
Thursday is a holiday, right?
Wednesday.
Wednesday is a holiday. So we'll decide tomorrow, but you can all meet in the evening so that, your side is completed on Friday. We don't mind stretching it a little more on Friday beyond 1 o'clock so that we don't come back after lunch. We'll give you a little more time.
Finish it by Friday.
Do this on Friday, we can start at 10. So we give you 3 hours on a trot and wrap up on at 1 o'clock for your side. So at least we're giving you a little more time on Friday.
we'll, my lord, discuss and, my lord, come back tomorrow.
Give us a solution. I know, but everybody now has to, because we've heard the other side, so we've seen the entire material. Now we are hearing submissions really, because we don't have to read. Now even the judgments have been read out to us, so
Keep it as short as possible, but some.
that's all that we are requesting. We are sure that you can achieve it. Mr. Giri, we are,
Then, let's see. Lordship said same. When it went on the other side also, somebody was given half an hour, 2 hours. We'll not do that. Some perspectives will have to be placed. Lordship's may most graciously take note of the fact that.
all right, but please do meet this evening in a way that, on Friday, between 10 and 1, we will hear you on a trot for 3 hours and we'll conclude this side on Friday. Then we'll give them Monday and Tuesday to wrap up the rejoinders.
Will Lordships then give us time for the whole of Friday, we'll do.
There's some difficulty about
Very
the whole
well.
of Friday. That's why we are saying.
Very, very, very.
Obliged to.